For more on the story, we're joined now by legal analyst Mpumelelo Zikalala. Mr. Zikalala, good evening to you. Thanks for your time. So looking at this matter, the former president ending up in the Constitutional Court, I mean, the ironies are plenty, but certainly interesting to look at how that particular case may unfold.
Definitely. In fact, in the case in the Court, I think it's going to hinge on two things. Before we actually delve into the merits, the first one would be, do we have a proper appeal that has been placed or launched in the Constitutional Court, taking into account that what was initially asked for by the former president team is that the directive or the order must that the SCA must go back and look at the matter. However, the Court replied and said, no, we're not going to go in that particular avenue. But what we are invited to do, former president, is to make a representation as to whether the merits of this matter must be investigated. Meaning, should we employ a wider definition to the title of no title to prosecute, or should we limit it to what we currently have now? If we then provide an expanded definition, it may mean that you are going to win in your argument in terms of saying, let's not only look at the administrative compliances or administrative requirements when the prosecutor is assessed whether they've tried to prosecute or not. Let's also look at the conduct of the prosecutor. In this case, I'm pretty sure that the former president will then want to say, can I then supplement my papers? Because I have new information that has come to light. There are certain criminal proceedings which are now taking place, which adds on or fuels to my allegations of saying that we have a prosecutor here who does not only want to do its job, however, they're hell-bent and due to personal circumstances and motives that they want to make sure that they're able to prosecute me come hell or high water. So that's what the Constitutional Court will have to deal with at a later stage.
When it comes to the decision that the Constitutional Court will ultimately come to, of course, many South Africans would have in their minds the fact that this would have been the very same court that has sent the former president to jail, albeit in a completely separate matter, but certainly somebody at the time who was defined in court judgments as having defied even the weight and the standing of the court.
However, we have confidence that our justices look at every single case and its own merits, regardless of the history of the litigant that is in front of them. They then have to say, what are the merits which are in front of me? What do the court papers say? What does the law say? What does the spirit of the Constitution then says? And then it is my responsibility as a justice of the court to make sure that I'm able to develop this particular legal principle or protect or develop or interpret legislation as it has been written, to make sure that it is able to cover the basics when it comes to our Bill of Rights. In this case, the Bill of Rights that was specifically looking into Section 35 of our Constitution, the one that says every criminal trial must be a fair one, and every opportunity must then be granted to an accused person, in this case, the former president, in order to defend his or her matter. So when the matter is placed in front of them, they even forget that they've dealt with any other matter in which contains the former president before, and they have to look at the merits as they are and the facts as they are, and also the submissions which are going to be made by the legal representatives of both parties.
Do you foresee a situation where some of the justices of the court will have to recuse themselves from actually presiding over this matter? And, of course, the Chief Justice would be one that takes preeminence in terms of why it would be seen as problematic given the history that they have.
I think they would want to say we are going to be justices of the Constitutional Court. We are employed and we have taken oath to make sure that we look at every single matter on its own merits. If a litigant has a problem with any of the justices being there, they are free to make an application for a recusal. And if they can be able to substantiate why that particular application should be there, and there's reasonable apprehension in the mind of the applicant that this person who's sitting there is going to make a decision which is adverse to them due to instances or circumstances which do not contain the actual matter or which are influenced by third forces, then they can come back and say we are going to recuse ourselves. However, it would be important for the justices of the court to then say, we are going to sit here and listen to your matter. If you feel that there are merits in application for a recusal application, then you can go ahead and do it. That's why we have these legal prescripts and principle that allows us to engage in these type of things so that you can actually see that justice is being done and you don't only read about it in our judgments.
Mpumelelo, just lastly, one of the things that Judge Piet Koen would be mindful of is just how long the matter in the Constitutional Court will take to resolve in making a determination on what happens then to the case that's before the Pietermaritzburg High Court. How many more legs does, this case have in terms of how much further these external processes can go on for?
It must be given as much as possible or much as is required. Let's remember that as much as certain individuals will come and say, no, there are stolen grant activities, there's nothing more than wasting of time. It is the protection of one's legal interest. If you have that particular legal interest available to you, I'm sure if any of South Africans are put in that particular position, they would want to employ it and want to explore those particular legal prescripts as they are. Now, let's remember that you have the Constitution that tells you how criminal matters should be handled. You also have the Criminal Procedure Act that tells you how criminal matters should be handled, and any unreasonable delays are then investigated. It was done today. So today was a prime example of saying, let the legal or the litigants come to the party, make their written submissions, and make sure that they're able to assess whether those particular postponements are valid or not. I did feel, though, that the application by the state was a bit of an ambush, at least some knowledge and maybe adequate notice of saying that you are going to bring in a comprehensive application such as this one should have been sent to the team of the former president, and a separate date ought to have been set by the judge to then say, I want you to come to court well prepared and fully ventilated. He still has an opportunity to do that on Wednesday. He can come back and say, I'm giving you 2-3 weeks to come back and make these particular submissions. They're going to be very important in the conduct of this case and how this case is going to be handled moving forward. Also, is the issue of him indirectly saying that I may recuse myself in this particular matter. I may have been too involved and made certain utterances which are going to place me into trouble at a later stage, taking the developments that have taken place with regard to private prosecution. So Wednesday's ruling is going to be very crucial in terms of the discourse which is going to be employed in making sure that this case is heard and dealt with by our courts.
Mpumelelo Zikalala, we'll leave it there for tonight. Thanks for your time.